All rise, veuillez vous lever. Please be seated.
Well, good afternoon. The Appeals Chamber will now hear Mr. Simatović's response. Counsel, you have 45 minutes for this, and we will really appreciate if you speak slowly and make pauses from time to time so that you make the work easier for the persons who are doing the transcript. Thank you very much.
Hvala, časni sud.
Thank you, Your Honor. We will do our best to abide by your instruction.
Najpre, odbrana.
First of all, Franco Simatović's defense would like to point out that we stand by our submissions from our reply to the prosecution appeal. We would like to state that all of the submissions in the prosecution appeal brief are erroneous, and we believe that it should be rejected in its entirety. I will address some of the aspects of our reply. And in terms of our detailed response, I refer the appeals chamber to our written submission, our written brief. As regards the subground 1A of the prosecution appeal, it is proposed therein that the trial chamber applied the wrong legal standard and erroneously limited the definition of contribution and assessed the importance of the contribution by the accused. The defense holds that such prosecution submission is wrong and that it does not comport with the explanation provided in the trial judgment. Namely, the trial chamber dedicated the entire fifth part of the judgment to analyzing the contribution by the accused. The trial chamber carefully analyzed their contribution to the unit, to the SDG, the Scorpions, and then their contribution pertaining to the SAO Krajina and the SAO SBWS, as well as Bosnia and Herzegovina. The trial chamber analyzed all aspects of their contribution as set out in the indictment. In addition, the trial chamber analyzed the contribution not included in the indictment, but stipulated during the prosecution case, which kept evolving over the 20 years duration of these proceedings. The gist of the prosecution objection is that, in their view, the trial chamber limited itself to the conduct related to the charged crimes only. This defense believes that only such evidence as contained in the indictment pertaining to common criminal purpose contribution can be assessed. The trial chamber, however, went much further in its analysis. It analyzed all events pointed out by the prosecution, regardless of whether they were mentioned in the indictment or occurred as a result of prosecution investigation that had not been concluded until the very end of the trial. It is clear, for example, if we look at paragraph 388 of the trial judgment, where, regarding the unit, the trial chamber analyzed the camps in Lezhimir, Paizosh, Šamarica, Korenica, as well as Tara in paragraph 433 and Tikvish in paragraph 406. In paragraphs 162 to 168 of the judgment, it also analyzed the events in Western Srem, which is something we will address later. None of the locations appear in the indictment, and yet they were subjected to rigorous analysis by the trial chamber. Finally, The trial chamber in paragraphs 434 and 597 of the judgment state its position regarding the responsibility of the accused. The trial chamber, in concluding on JCE liability, in paragraph 598, relies on a single phrase a trial chamber can use when considering the existence or non-existence of the responsibility by the accused. It finds that the accused are not responsible for the commission of crimes contained in the indictment through the JCE. In no other way could the trial chamber express its position, having analyzed the allegations not found in the indictment at all. However, the prosecution submits that the trial chamber adopted a wrong legal standard. It seems that they believe that in the absence of evidence about the charged crimes, the trial chamber could establish guilt for acts not contained in the indictment. Although, in this defense's opinion, the trial chamber's approach was unjustified, their conclusion is unambiguous. There is no liability concerning the acts in the indictment, and there is no liability for acts not contained in the indictment that could potentially amount to any grounds to establish liability through JCE participation. In paragraphs 27 to 33 of their appeal brief, the prosecution state that the accused contributed to the CCP by financing, training, and commanding the Serb forces which allegedly took part in ethnic cleansing operations in Podrinje in 1993. Completely arbitrarily, the prosecution included Podrinje among the large swaths of land in Bosnia where there was alleged forcible and permanent removal of non-Serbs. In doing so, the prosecution uses a fragmented view, completely overlooking the context and chronology of events. The activities, which included the Serbian MUP, amounted only to a legitimate attempt on the part of the Republic of Serbia to defend state territory and the population, and yet the prosecution portrays it as ethnic cleansing in eastern Bosnia. It is particularly striking that they try to link the accused Simatović to the training on the Tara, despite the fact that Obrad Stevanović, a senior MUP of Serbia official, testified, saying at the time that there was a staff in Bajina Bašta which he headed. He also stated that the Tara camp was established on his request and that he commanded the training. There is another striking example contained in paragraph 34 of the appeal brief of the prosecution. The prosecution claimed that the trial chamber failed to consider Simatovic's involvement in operations Pauk and Treskavica in 1994 and 1995. This too is seen by the prosecution as part of the contribution to common criminal purpose. Here too, the prosecution ignored the indictment. Here too, the prosecution demonstrates its position that any activity between 1991 and 1995 is evidence of CCP contribution. When it comes to the Serb side, the prosecution practically identifies any military activities to CCP contribution. It is also particularly striking when we discuss Operation Pauk. Put briefly, it was an attempt to assist the Muslim population in western Bosnia and ease the humanitarian crisis which occurred in the RSK as a consequence of the inter-Muslim conflict in western Bosnia. However, for the prosecutor, this too amounts to CCP contribution. They completely disregard the context and dynamics of the event. Another good example of that view is the Serbian MUP activity in the environs of Banja Luka in the fall of 1995, as stated in paragraph 35 of the prosecution appeal brief. The participation of the RJB MUP of Serbia units amidst a humanitarian catastrophe and havoc caused by a mass movement of 200,000 refugees from Knin and other places in the RSK is presented as an attempt to secure the previously ethnically cleansed territory. This lack of critical analysis and sensibility can only be compared to the prosecution's complete abandonment of the indictment as the basic document in any modern-day criminal legal system. The prosecution also holds it against the trial chamber, saying that they analyzed the contribution in a fragmentary way, therefore arriving at a conclusion that the contribution was insufficient. We can find that in paragraphs 57 to 59 of their appeal. However, it is incorrect. The TC, the trial chamber, analyzed the participants, the specific activities by the accused, as well as the events in specific territory. All such analysis result in paragraph 557 and 558 of the trial judgment. The analytical process applied by the trial chamber is completely in line with the jurisprudence, and the prosecutor fails to show any kind of error by the trial chamber in that regard. The prosecutor's allegation concerning the alleged errors by the trial chamber for failing to establish whether the accused aided and abetted the crimes in Sao Krajina, Sao SBWS, Doboj and Sanski Most, contained in the subground 2B of their appeal, is completely unfounded. We discussed the reasons in detail in our reply to the prosecution's appeal. The defense concludes that neither the appeal ground 1 pertaining to Simatović's liability as a JCE member, nor the ground 2 pertaining to Simatović's responsibility to aiding and abetting are founded. The appeals chamber has every reason to dismiss the prosecution appeal and to confirm the trial judgment as challenged by the OTP. A few words now concerning the questions put by the appeals chamber. First, Western Srem, whereas my colleague will deal with Sanski Most. First, we need to state that the locations in Western Srem referred to in paragraph 49 of the OTP brief, the places being Babska and Šarengrad, are not mentioned in the indictment. The indictment is very clear as to what localities it refers to. Although Babska and Šarengrad are not included in the indictment, the trial chamber did analyze the events in those two locations. In paragraph 162 of the judgment, it stated that it heard some evidence pertaining to the locations, but that such evidence is insufficient to conclude that members of the unit participated in the crimes. There is only unclear and contradictory evidence of the unit members' participation in any combat. In footnote 779 of the trial judgment, the trial chamber analyzed all evidence relied on by the prosecution in paragraphs 49 and 96 to 102 of their appeal brief. The conclusion of the trial chamber is the only one possible. The evidence led is insufficient to conclude that the members of the unit, as labeled by the trial chamber, were involved in the commission of crimes in Babska and Šarengrad. The prosecution relied on several pieces of evidence, and for the sake of caution, I'd like to ask to move into private session for this brief submission.
Please.
We're back in open session. Thank you.
Hvala. Na osnovu
Thank you. Based on such evidence, and the prosecutor never directed you to any other evidence, the trial chamber could only arrive at the conclusion they did in paragraph 162 of the trial judgment. As regards a more specific answer to your questions, Your Honor, I dare say that for responsibility for JCE or aiding and abetting to exist, it can only be established only if there is evidence that the persons linked to Simatović in any way were involved in the commission of the crimes. Based on confusing evidence I referred to, no conclusion about a crime or participation in combat could be arrived at. The evidence referring to Sharengrad and Babska provide no ground to conclude whether there was any combat, who participated, or whether any crimes were committed. Significant contribution pertaining to JCE or substantial assistance to the perpetrators, if we are discussing aiding and abetting, on this factual basis is completely excluded. Therefore, in response to your question under B, is that the prosecutor should prove beyond a reasonable doubt that the members of the unit committed crimes. The prosecutor did not prove neither that the members committed crimes, nor did they prove that they took part in any operations at all, thus substantially assisting the perpetrators or contributing to the commission. This defense concludes that all submissions concerning Sharengrad and Babska point to the conclusion that was arrived at by the trial chamber, which is that responsibility in that sense is not possible when it comes to the two locations. Thank you, Your Honor, and I will turn the floor to my colleague, Mr. Bakac.
Hvala.
Thank you. One of the key issues in the prosecution's appeal, which the OTP has highlighted yet again today, is their submission that the accused, Stanišić and Simatović, contributed to the CCP by supporting Arkan and his SDG. The prosecutor objects to the trial chamber's dismissal of Stanišić's and Simatović's contribution through Arkan and the SDG on the grounds that the accused did not support any specific SDG members who were involved in the commission of crimes in Croatia and Bosnia and Herzegovina as per the indictment. The prosecutor's objection absolutely does not stand. The defense's position is that the trial chamber stayed well within the framework of the indictment and the prosecutor's submissions found in the pre-trial brief. We are of the opinion that the trial chamber implicitly expressed its position in the first instance judgment, that it is not authorized to overstep the indictment boundaries, and that in the analysis of this issue in the judgment, it focused on the charges proposed by the OTP in the indictment. The OTP's position that the trial chamber failed to analyze whether the support extended to Arkan and the SDG played a role in the JCE as a whole is unacceptable. In the judgment, the trial chamber addressed the vast number of individuals who shared a joint criminal plan, and the trial chamber did not include Simatović in this group of high-ranking political, police and military leaders. However, it explicitly stated that it would examine all the evidence regarding his alleged contribution to the CCP. Indeed, the trial chamber did this in paragraphs 380 to 181 of the judgment. Also, in paragraphs 382 to 436, the trial chamber examined Simatović's alleged contribution through the unit, taking into account the ample evidence which the trial chamber examined in detail. In paragraphs 437 to 456 of the first instance judgment, the trial chamber also thoroughly and extensively examined Simatović's alleged contribution to the CCP through Arkan and his SDG. At this point, the defense would like to draw the appeals chamber's attention to para 446 of the first instance judgment. Having analyzed numerous documents and transcripts, the trial chamber finds that there is evidence about the key involvement of other important individuals and institutions which provided support and sponsorship to Arkan and his SDG. Thus, the trial chamber finds absolutely correctly that the evidence about the key involvement of important individuals and institutions that supported and sponsored Arkan and the SDG, especially in combination with the absence of concrete evidence about Simatović's direct involvement, raise additional concern. When analyzing the involvement of Arkan and the SDG in crimes in Bielin and Zvornik, the trial chamber clearly and unequivocally draws a conclusion that the evidence presented by the OTP to prove that Arkan and the SDG acted under the authority of the accused is very weak. The trial chamber has indeed analyzed this evidence in great detail and drawn the correct conclusion. In its written submission, the defense provided a detailed response to this part of the prosecutor's appeal brief, from which it can be clearly concluded that the trial chamber indeed analyzed in great detail Simatović's possible support to Arkan and the SDG and the possible contribution arising from such support to the joint criminal plan. The OTP also submits that the trial chamber failed to analyze whether Simatović's logistical or financial support contributed to his activities in furthering the joint criminal plan. On the contrary, the trial chamber did analyze the alleged logistical or financial support by the accused in the light of all the crimes charged and alleged by the OTP, including such support to Arkan and the SDG for their participation in some operations, as well as through the prism of the possible contribution of the accused to the joint criminal plan as a whole. The defense draws the appeals chamber's attention to paragraphs 444 and 453 of the first instance judgment and reiterates that the trial chamber assumed the right stance and stayed within the limits of the crimes charged and alleged in the OTP's closing brief. The defense has already pointed out that for the duration of both trials, no single piece of valid evidence has been adduced about Simatović's capacity to provide either logistical or financial support to Arkan and the SDG. Yesterday, in its oral submissions and its appeals brief, the defense clearly explained which positions Simatović held at the time relevant for this case, as well as the scope and type of tasks he carried out. During both trials, the defense proffered ample evidence and demonstrated that a separate RDB administration was in charge of all logistical and financial support. It was the 8th administration headed by Milan Prodanić, who neither de jure nor de facto reported to Franko Simatović. On the contrary, as the head of the 8th administration, Milan Prodanić's position was above Simatović's in the hierarchy. Thus, it remains unclear why the OTP insists on Simatović's role in providing logistical and financial support to anybody, including Arkan and his SDG. without a solid ground for such an assertion. In its appeals brief, the OTP proffers nothing but some rather weak evidence which fails to meet the probative value requirement that Simatović was in any way involved in financing Arkan and the SDG. Moreover, Simatović had no capacity to provide a logistical and financial support to Arkan and the SDG. Also, he had no capacity to deploy Arkan and his SDG. In his appeal submissions, the OTP refers to witnesses RFJ088, RFJ011, and RFJ041, but this evidence can in no way corroborate the OTP's argument. In its written response, the defense analyzed in great detail the credibility of witness RFJ088 in paragraphs 108 to 114, highlighting the key material evidence which thoroughly compromised this witness's testimony. Furthermore, the testimony of RFJ011 and RFJ041 cannot be considered evidence on which any reasonable trier of fact could conclude beyond any reasonable doubt that Simatović had anything to do with the financing and logistical supporting of Arkan and his SDG. A comparison of the relevant parts of these two testimonies relative to Simatović's alleged contribution, i.e. deployment of forces and their financing, clearly shows that the two contradict rather than corroborate each other. In its appeal submissions, the OTP refers to these two witnesses' statements and focuses on some minor parts thereof, taking them out of the context in order to support their arguments. The defense would like to draw the appeals chamber's attention to the fact that these witnesses' testimonies need to be examined in their entirety, as this is the only way to show that these testimonies cannot prove a concrete link between Arkan and the SDG on the one hand and Simatović on the other. The defense submits that the trial chamber quite correctly drew the same conclusion in paragraphs 446 to 448 of the first instance judgment. In one of its appeals grounds, the OTP submits that the trial chamber failed to draw a conclusion as to whether the accused contributed to the joint criminal plan by deploying Serb forces to Sanski Most. We have already pointed to the fact that in its appeals brief, the OTP does not cite the part of the judgment to which this refers, but it rather refers to the indictment, to its pre-trial brief, and to its final trial brief. In its written submission, the defense provided a detailed response to this ground of the OTP appeal in paragraphs 237 to 306. However, we find it important to reiterate that the OTP did not proffer a precise indication as to which forces the accused allegedly deployed in that area.
We can talk about it, but please.
Izvinjavam se.
I apologize. I apologize to the interpreters as well.
Na tužilaštvu je
the burden of proof is on the prosecution. The prosecution was duty-bound to precisely determine which Serbian forces allegedly deployed by the accused were on the territory, if there were indeed others there as well. Therefore, it remains unclear which Serb forces are referred to in this appeal ground. The burden of proof is on the prosecution. The prosecution's task was to pinpoint forces allegedly deployed by the accused to Sanski Most in 1995 and proffer strong evidence to corroborate that. It is the defense's position that admitting this appeal ground would be a serious violation of the right of the accused to a fair and just trial. Throughout the proceedings, the prosecutor's case was that 300 to 400 men mentioned by Stanišić at a meeting, as recorded by Mladić in his diary, were actually SDG members. During the proceedings, the OTP did not provide an alternative to this allegation. However, in its appeal brief, the OTP argues that although the trial chamber was not convinced that the 300 to 400 men in question were SDG members, it should have examined whether their engagement in this operation was a contribution to the CCP. We find this position totally unacceptable and bordering on absurd, as there is no single piece of evidence establishing exactly who these 300 to 400 men were, whether they were engaged in combat, i.e., what activities they pursued during the relevant period in this territory, so as to determine their possible contribution to the joint criminal plan. There is ample evidence and number of witness statements to which the defense refers in its written response, showing that the MUP of the Republic of Serbia deployed precisely 400 policemen to the area of Sanski Most and Banja Luka, Krajina, during the period between August and November 1995. The aforementioned PJP forces were deployed at the request of the MUP of the Republika Srpska, and they were engaged pursuant to the decision of the RJB chief Radovan Stojičić. It is also worth mentioning that these PJP members were resubordinated to the local police stations, and that in the execution of their regular policing duties, patrolling, keeping public law and order, and regulating traffic, they were under the command and control of the local police chiefs. The defense covers this in great detail in its written response in paragraphs 249 to 269. And it provided the appeals chamber with plenty of evidence with this regard. The OTP also submits that the trial chamber erred by not establishing that Simatović contributed to the JCE by financing the SDG members who were engaged in operations in Sanski Most in 1995. It is the defense's submission that the OTP, in the effort to corroborate its argument, misinterprets the trial chamber's finding by stating that the trial chamber accepted the evidence that the Serbian state security paid some SDG members who may have perpetrated the crime of forcible removal of people from Sanski Most in 1995. That the trial chamber established that at least 4 SDG members committed the crimes of unlawful detention, torture, and murder, and that, as a result, the non-Serb population of Sanski Most was driven away. The defense rejects such claims by the prosecution and believes that in the judgment the trial chamber provided explicit explanation of its finding as to whether the accused financed Arkan and the SDG. Also, it is our submission that the trial chamber examined the Serbian Security Service payroll, which included some SDG members, including the payroll for 1995 when operations were underway in Banja Luka and Krajina.
In paragraph 453 of the trial chamber's judgment, the trial chamber finds that this evidence is largely limited with regards to the extent to which the individuals on the payroll participated in the operation. The trial chamber concluded, rightly, that this evidence is insufficient to establish the responsibility of the accused for financing Arkan and the SDG beyond a reasonable doubt. The Simatović defense holds that during the proceedings, it became clear that the issue of the per diem lists became highly questionable and that numerous witnesses expressed their doubts in that regard. The defense believes that the lists in and of themselves do not amount to reliable evidence, making their probative value very low, as rightly concluded by the trial chamber. This defense's position is best illustrated by no other than a prosecution witness, the witness being RFJ 041. The prosecution relied heavily on his testimony. He found his name on the list and was an SDG member. in his testimony on the 5th of December 2017, on page 36 of the transcript, the witness, having been shown the lists, stated that he recognizes his name alongside several others he can confirm, whereas he didn't know any other names. In addition, the witness pointed out that he had no further knowledge about the lists and that he didn't know the purpose of the payments. It was said so in his testimony on the 6th of December 2017 on pages 19 to 21 of the transcript. What we'd like to point out as well today to the appeals chamber is the fact that the witness accepted decidedly that and agreed to his name being found on the list for per diems, even on the days when he did not participate in combat, and that he was not the only such example. He also testified that between the 20th of November 1994 and the 20th of April 1995, he did not spend time in Bosnia at all. He didn't participate in any combat and he was out of the country, and yet his name was on the lists pertaining to the period. RFJ 011, as my learned friend Mr. Jordash discussed, also recognized only some of the names, and I will not discuss this in further detail. Perhaps in response to your question 1A concerning the pay lists in Sanski Most, we should also address the issue of to what extent those persons participated in the operation, or to be even more specific, to having participated in the crimes. If we apply the standard even more broadly than that applied by the trial chamber, based on the evidence proffered by the prosecution, we could see, you can see, that all evidence about the pay lists is unreliable. It does not confirm even the presence of certain people in a certain place at the alleged time where the crimes were allegedly committed and where the JCE was put into practice. It is also telling that the prosecution relied or attempted to use this evidence about the lists to prove the Serbian DB's financing of Arkan and SDG members, although none of the admitted pay lists mention the name of Željko Ražnatović Arkan. Our learned friend on the opposing side, when discussing Sanski Most, said Arkan was active and present there during the operation in September and October. My question then is, if the pay lists amount to evidence, where can we find Arkan's name on the lists? You won't find a single list with his name. To go back to what I just said, it is abundantly clear that the pay lists are completely unreliable in terms of any evidence to prove any financing. In addition to the unreliability of the pay lists, in our written submissions and oral arguments, we also pointed out that there are numerous witnesses who were shown the lists, who expressed their serious reservations concerning the documents, saying or showing that this is no evidence of Serbian DG's financing of certain people appearing on the lists. My learned friend Mr. Jordash already discussed who appeared on the lists. That is why the defense is of the view that the lists cannot be placed in the context of SDG financing, nor do they support furthering the CCP. The lists can also not be considered in the context of financing that would amount to aiding and abetting the crimes in Sanski Most. In their oral arguments today, the prosecutor stated that it was precisely Simatović who signed the pay lists throughout 1995. I invite you to look at the evidence, and I claim that it is completely incorrect. In several pay lists in January 95 and May 95, before the events in Bosanski Shamac, you can find Simatovic's Simatovic's signature, but it was signed for Radović. On 6 pay lists, you will also find the signature of Krsmanović, who also signed on behalf of Radović. So signing in lieu of another is no proof of any key role in financing, nor does it demonstrate one's capacity or ability to decide on the matters of financing. The prosecutor invokes an administrative, bureaucratic red tape practice and serve it as evidence. When it comes to your questions B and C in relation to Sanski Most, I would like to ask the appeals chamber to consider the potential contribution by the accused in terms of the alleged financing of the SDG in Sanski Most in 1995, to see it through the prism of evidence and facts, taking into account the context at the time and bearing in mind the circumstances which resulted in the operation in Sanski Most. I would like to remind you that Operation Storm in the Knin Krajina took place on the 4th of August 1995, and that there were 200,000 refugees who had fled the area moving towards Bosanska Krajina. At that moment, the two armies of the Croatian Serb army and the JNA's 5th Army were joined, moving in unison towards Banja Luka. That is why the prosecution conclusion that the operations in Sanski Most and Bosanska Krajina were intended to secure the results of previous ethnic cleansing does not stand. There is no basis for such a conclusion in the evidence. The goal of the operation in Sanski Most, as shown by much evidence offered to you and to the trial chamber, the goal was, as shown by the evidence, to prevent any further offensive by Croatian forces and to protect the 200,000 refugees who had fled. In view of this defense, the operation was a legitimate military activity to put a stop to an offensive. In our view, the crimes that happened were excesses. They had nothing to do with ethnic cleansing, which, according to the OTP, had taken place in 1992. The position of the prosecution is that the structure of the population changed between February 1995 to 1997 is also something that does not stand. In December 1995, we saw the arrival of the Dayton Accords, when the two entities were merged. And in 1996 and 1997, we don't know why the ethnic composition changed and why some people may have moved. This cannot be used as an argument to justify the operation in 1995 or to say that the operation was meant to secure the result of previous ethnic cleansing based on this unreliable evidence. Between 1995 and 1997, as I said, there were different motives, different reasons for people to change their residence, having in mind the creation of the two new entities.
Time you had, you can have some more minutes to conclude, but please do it in 2-3 minutes, please.
Hvala, čast.
Thank you, Your Honor. To conclude,
Dakle, kao što su moje uvažene kolege
as my learned friends have already stated, and in answering your questions, BNC, about Sanski Most, we submit that any possible financing of a limited number of men was not enough to demonstrate that this type of financing was aimed at chasing away the remaining number of non-Serbs. There is no evidence to that effect. The financing of a limited number of SDG members could not have constituted a contribution in order to further the CCP. And I don't want to go over the same ground again, but as I said, it could not be construed as aiding and abetting the crimes that happened in the area. Thank you very much.
Counsel, and now we are going to hear the prosecution's reply. Counsel for the prosecution, you have 20 minutes for this, so you can proceed.
Thank you, Your Honors. I have 5 points to make in reply. The first one concerns the JCE so-called tools test. The prosecution is not arguing guilt by association. Stanisić's unidentified or undefined JCE tools test ignores the settled law. The prosecution did not charge, and the trial chamber did not need to find that every tool used by the JCE were tools of Stanišić and Simatović. What matters is whether the principal perpetrators of the crimes, quote, were used by the accused or by any other member of the joint criminal enterprise in order to carry out the actus reus of the crime, forming part of the common purpose, end quote. And I would refer Your Honors to the Karamera appeals judgment, paragraph 605, and the Nizeyimana appeals judgment at paragraph 325. I'm going to ask my colleague, Ms. Stewart, to pull up a quick slide just to illustrate this concept. It's very simplified, but Your Honors, if A, B, and C are in a joint criminal enterprise, and A is using tools, and B is using tools, and C may or may not be using anybody, may be contributing in other ways, all 3 JCE members are still responsible for the crimes imputed through the tools test to the JCE. And that test is what links A to A's tools. There is no requirement that C be directly linked to A's tools except through the JCE itself. The slide can go off. For my second point, I'd like to address the credibility challenges regarding RFJ 088. In their submissions today, the credibility of this witness has been attacked. while the trial chamber that is best placed to assess the credibility of a witness and the reliability of that witness's testimony viewed this witness's evidence with caution, it did not find the witness's evidence to lack probative value in its entirety. And Stanišić and Simatović failed to show that the chamber abused its discretion in the credibility and reliability assessment, or that the appeals chamber should not rely on the evidence of this witness. And I would like a very short closed session so I can go into a little bit of detail here.
We can go on closed session, please.
We're back in open session. Thank you.
Okay. The evidence of the witnesses, this is my third point. It's about the Sansky Most payment lists. The evidence of the witnesses affiliated with the SDG, which we've already highlighted, is clear that the SDG units were paid as a whole for their deployments. And any contrary reading is not supported by the evidence. The SDG members who identified their own names on the payment lists, whether that's for Sansky Most or for any other operation, were low-level rank and file. They were not people who would have been receiving personal favors from Serbia's state security service. And I'm going to have to ask for a second private session. This is the last one, Your Honors.
We're back in open session. Thank you.
Thank you. Your Honors, let's look at the lowest common denominator for the Serbian state security payments in Sanski Most. You heard 7 of Arkan's men who we can name as being involved in the operations, of which there is specific evidence that 4 were involved in ethnic violence. Let's look at what these 4 were doing. And this is the evidence in 1826 of the trial judgment. They shot Muslim civilians in mosques as they prayed. They shot Muslim civilians in their homes. They tortured detainees, and they ordered the random execution of detainees. This is what the SDG was doing in Sanski Most in September and October of 1995. They were behaving exactly as they had in SBWS in 1991 and in Zvornik and Bielinia in 1992. Brutal and notorious crimes that persecuted and forcibly displaced non-Serbs. There can be no doubt that paying this kind of unit, openly committing this kind of crimes, furthered the common criminal purpose and had a substantial effect on the crimes. Yesterday, the defense wanted criminal propensity and a JCE member on the ground. This is not legally required, but you have this in Sanski Most. And the defense has attempted to downplay the reliability of the payment lists. But Stanisić's own witness testified to the internal authenticity of the lists. He stated that he did not reasonably believe that it was possible that after he signed the per diem lists, additional lists containing the names of SDG members were slipped into the documentation. And I would refer you to 1D385 at transcript page 14661. Your Honors, this brings me to my third point concerning Western SRAM. As Your Honors will see when you review the evidence referred to in the prosecution's submissions, the unit was involved in the ethnic cleansing operation in Western SRAM that went in ways that went beyond the single day that my learned friends have focused on. Their involvement also included prior reconnaissance, Simatović's advanced coordination with the JNA, and their presence in the area after the combat was over, sweeping the terrain and setting up a forward command post and then a camp. An insurmountable threat to any non-Serb refugee who wished to return. And I would note that not all of this evidence comes from RFJ 137. And I need another private session.
We're in open session, Your Honors. Thank you.
Your Honors, notwithstanding any concern that Stanišić and Simatović may have had about the unit's involvement, they still deployed the unit with the JNA a few months later into the Bosanski Shamats operation. The local men from Bosanski Shamats came to Pajos camp in Western Srem, where they were trained by unit members alongside the SAO SBW police. And I would note that the chamber listed the SAO SBWS police as one of the perpetrator groups in the same Western Srem ethnic cleansing campaign in the fall of 1991. And that's at trial judgment, paragraph 168. My final point is on pattern. Your Honors, the defense has been on notice since the ICTY trial began that pattern operations were charged as contributions to the joint criminal enterprise. Not as charged criminal incidents, not something that they could be directly convicted of as a crime-based incident, but as contributions to the JCE to show the joint criminal enterprise's full scope and the pattern of conduct. This was made clear in the prosecution's pretrial briefs and final briefs, and the defense defended against these charges in the ICTY trial and again during the retrial. And I would refer you to the brief cited at paragraph 9 of our reply to Stanisić's response brief, as well as to Stanisić's retrial final brief in which he defended against the allegations concerning Birchko, PAUK, Eastern Bosnia-Herzegovina, and the 1995 SBWS operations. To conclude, Your Honors, as we've argued today, the retrial chamber committed serious errors in both its JCE and aiding and abetting analysis. It failed to consider legally relevant JCE contributions. It failed to consider relevant evidence of intent. It failed to apply the beyond reasonable doubt standard to the totality of the evidence. And it failed to turn its mind to whether Stanišić and Simatović aided and abetted the crimes anywhere other than in Bosanski Shamats. As a result, the chamber failed to deliver the justice that was the aim of this retrial to the international community and, most importantly, to the victims. And this task now falls to Your Honors. Unless you have any questions, this concludes the prosecution's submissions.
Thank you, counsel. The chamber has no questions. So that takes me to the last item on the agenda for our hearing today, and this is the optional personal statements of Mr. Stanišić and Mr. Simatović, should they wish to make one. So I will ask Mr. Stanišić on the first place if you would like to make a personal statement, and if you do, it will not be able to be longer than 10 minutes. Please keep that in mind.
Your Honor, I would like to thank you for your willingness to listen to us. From day one, I have given my trust to Mr. Jordash and my defense team to what they have done and what they have said. So I would like to adhere to that. So I don't want to say anything else. Thank you very much.
Thank you. Mr. Simatović, would you like to make a personal statement? Also, it should be no longer than 10 minutes if you accept to do so.
Your Honor, thank you for allowing me to say something. However, I believe that my defense lawyers have shown the position of the defense very well today, so I have nothing to add to that. Thank you very much.
Thank you, Mr. Simatović. And, well, then this concludes the hearing of the appeals in this case. And before we adjourn, I would like to take a moment to thank the parties for their work on this case. And additionally, I wish to express my gratitude to the registrar and all the mechanism and contracted staff for their excellent assistance in facilitating the hearings today and also yesterday. So the appeals chamber will render its judgment in due course, and we are adjourned.
All rise, veuillez vous lever.